Thank you, Mr. Chief Justice, honorable members of the court, Justice Blackmun, Mr. Doherty, good morning. I thank you for the opportunity to address the court. Your Honors, if I might, I would like to address first one issue that the appellant raises in his brief that I feel in his reply brief that I feel needs to be clarified. We raised the issue whether or not the decision of the trial court was proper under E1A or E2B. Our position is that even if the court had applied the standard under E1A, which would include not only determining that the orders were in the best interest of the child, Demetra, but also that there had been changed circumstances, there were sufficient facts to establish the change of circumstances. Judge Zitter, in her decision, did not, as Mr. Doherty states, agrees, did not specifically state under which section she was making the decision. This was something the Court of Appeals stated.
Mr. Tesno, so when we're talking about these higher standards and which standard should apply, the best interest is for both. But in the higher standard, you would also have to show change of circumstances.
That is correct,
okay.
Your Honor.
All right.
Mr. Doherty and the appellant in their reply brief states that we're asking this court to determine what Judge Zitter would determine if this case were remanded. That is not what we're advocating. What we're advocating is that there are sufficient facts, if the court were to review the entry, that would reach that higher standard, and therefore the court does not have to reach the decision of which subsection would apply. Either subsection would apply on the facts given before the court in this case.
So you are indicating that the shared parenting plan is still in existence under the trial court's order?
That is correct, Your Honor.
So the trial court, the change of circumstances that occurred for the trial court was what?
Well, Your Honor, in reviewing it, the court found that the appellant had kept Demetra away from her mother in violation of the court's orders, that he had shown no remorse for the anxiety it had caused her in her child being kept away from her in violation of the court orders, that he had not exhibited any concern about violating the court's orders, that he denigrates the child in front of, or denigrates the mother in front of the child.
That may be a change of the shared parenting circumstances, but is it a traditional change of circumstances as we know it legally in Ohio?
I think it is, Your Honor. The Davis versus Flicklinger case, which the appellant cites in his brief, talks about what the change of circumstances need to be, and this court has ruled previously that that is a change of substance. There has to be sufficient change of circumstances that would reach that burden. I think that is something obviously for the trial court to determine on the facts of any given case, but I believe that the court had sufficient facts before it in this case. I would also submit to the court that if we accept the argument and the statute that says that in initially establishing a shared parenting plan, the court must determine what is in the best interest of the child. To modify or terminate the shared parenting plan at a later point in time, the court must determine what is in the best interest of the child. Some facts must have changed to change what is in the best interest of the child, and we would submit that those are always changes of substance. Something has changed for the best interest of the child, and Justice Blackmun, I believe you were asking earlier about words of art, and I think that's what we have here.
But isn't the best interest of the child a legal determination for a court to make?
Yes, Your Honor.
Not based really on change in the surroundings or physical environment of the child, is it?
Not by itself, Your Honor. I think it is. Yeah, the court has to look at the entire whole picture, look at the circumstances that are involved, and consider all the factors given at that time.
You know, what fascinates me about this case, how can you have shared parenting when you don't have co-parenting?
Your Honor, there is a lot of the, as I perceive it, a lot of the factors that go into shared parenting are still there. I think it is still incumbent on the parents to discuss matters, to keep each other informed as to what is going on with their child, to carry on as two parents should be expected to carry on for the best interest of their children.
But the statute doesn't implicate adversity when coming to the arrangement for shared parenting.
Yes, Your Honor.
It does?
It doesn't contemplate it, but it happens. In the real world, it happens all the time. That's why we're here. The parents don't get along 100%. But I think that the court can still tell the parents they have to act for the best interests of their child. And doing that, as I view
But
this...
the residential piece may be easy, but what about legal custodian? What does that mean?
Your Honor, in my view, what that means is one thing. In this case, this matter was originally brought back to the court because the appellant kept the child away from the appellee in violation of the court orders. By designating the appellee as residential parent and legal custodian, should he do that in the future, he would be possibly in violation of a criminal statute of interference of custody and could be prosecuted for that. So I think by making that change, the court has left that door open for criminal prosecution against him in the future should he try further actions like that.
Well, I realize that you've said that this case can be solved under both sections, under the change of circumstance section and under the lesser standard. Well, some may refer to it as a lesser standard, but it's the best interest of the child standard. But what do you do in a situation, in this kind of a case where the Court of Appeals has said that these terms, residential parent and legal custodian, are a part of the shared parenting agreement and therefore can be modified at any point in time? Obviously, the Court of Appeals saw some tension and some concern and not going the route that you're suggesting under the change of circumstance issue.
Yes, Your Honor. If I understand your question correctly, it's a question of can the court modify terms as opposed to the entire plan? Is that the question that you're asking?
Well, I'm concerned by, I realize that you have raised this question that this case can easily be solved under the change of circumstance section. So I wanted to return to the question that is before the court and what other courts have done as far as modification is concerned on this issue.
Yes, Your Honor. Okay, thank you. Your Honor, if you were to look at the entire section of 310904E, either subsection 1A or 2B, both dealing with when a court may modify a plan or an order, as I mentioned in my brief, the first sentence of 31094E2 states that in addition to the modifications permitted under E1, the court can make the following changes. So it's our position, Your Honor, that the statute specifically says that the lesser standard is a second choice. When you read subsection B2, it makes reference to modifying or changing the plan as incorporated in the decree. It appears, Your Honor, that this allows the court to modify any portion of it as opposed to under E1, the higher standard as we call it, which calls for the court to have to modify the entire plan. So whether we call the designation of residential parents a term or an allocation of rights or whatever under subsection E2, the court has that further authority to modify or to change a portion of this as opposed to the whole thing. It is interesting to note that under E2C, when it talks about terminating the plan totally, it talks about the standard being best interest. I think it's disingenuous to argue that you could terminate a plan solely on best interest, but you can't modify a plan under the same standard.